I just want to thank you for giving me the opportunity to co-host today. And I'm really excited because Keren and I have presented together on multiple occasions, and it was just enjoyable and a delight every time. And so I'm so glad that she's here today and to share some of her wisdom on mistakes that business owners make, which is something that I think we all know business owners make a lot of mistakes, and on a good thing, I guess if they didn't, uh, it wouldn't employ most of us on a daily basis if they didn't make any mistakes. So that can be a good thing. But Keren, you got her bio up here. She's a partner at Schwartz, Ettenger, and primarily focuses on estate and elder law. And again, today she is going to be sharing with us mistakes that business owners make with regards to estate planning and some of the things that they can do to kind of address and avoid those mistakes. So with no further ado, I'm going to pass it over to you, Keren.
Thank you, Alan. Thank you, Kyle. Good afternoon. Alan, you gave away my first slide. So thanks for allowing me to be here. Just a few housekeeping things. We're a small group. I'm very interactive, conversational. Feel free to interrupt me at any point in time. Just unmute yourself and start talking. No problem. Second is that we have a short amount of time, so I'm just scratching the surface. If you have a specific question as it relates to any of your clients or your specific matter, obviously feel free to reach out to me. And third is let's have a good time. All right, so without further ado, typically when I sit down with a client, I'll hear the following. I don't need to worry about an estate plan because I'm young or I'm healthy. I don't have a lot of assets. I don't really care. My favorite is I won't be here, so it doesn't matter. Especially for business owners, that is not true. If you've taken the time to grow your business, you've put the time in, you've put the effort, you put your blood, sweat, and tears, as I'll call it, into the business, you have people that you care about, whether it's your clients that you care about, whether it's your employees, whether it's the people you support with the funds you make from your business, there's somebody that you care about. So everybody needs an estate plan. It's regardless of the size of your assets. It's regardless if you're new to a business or you're a seasoned professional, you need an estate plan. So this can be applied to business owners, but it's applicable to everyone, whether you're a business owner, whether you're an individual, whether you're married, not married. These are common mistakes across the board, but specifically today, we'll gear it towards business owners. So without further ado, what is the biggest mistake of all time is not having an estate plan. So what is an estate plan, by the way? Does anybody want to chime in as to what they think an estate plan is? Anybody? Okay, I guess not. So what is an estate plan? An estate plan is ensuring a seamless transition of your assets and your personal benefit at death, but more importantly than that, it's also while you're alive. And people don't realize that an estate plan is not only for when you pass away. So I like to think of it as a toolbox, and forgive me for anybody who's heard me speak before, but I'll always mention this toolbox. What is my toolbox that I recommend everyone have? I recommend having advanced directives in the toolbox, which include my healthcare proxy, my living will, my power of attorney. I recommend having a will, which says where my assets go when I'm no longer here. I may need a trust depending on my situation. So different reasons why I may want a trust depends on whether I have estate tax concerns, maybe I have long-term care planning concerns. But also something people don't recognize is the need for either a prepaid funeral plan or an appointment of agents to control the disposition of remains, which means how do I get from being deceased to being buried? That's really not something I'll delve into in this conversation, but it's still something I recommend having in my toolbox. And why is it so important to have your estate plan in order? Well, typical example, what happens if you become disabled today? So just a few short weeks ago, actually, my daughter and I were in a car accident. Life can change like this. Thank God we're okay, but what if we weren't? What if I suffer a stroke? Yesterday, I got a call from a son of a man who was diagnosed with ALS just a few short months ago, and he's already disabled. Did not do the proper planning in that period of time. These are real life situations that happen all the time. And especially given COVID, we all see how things can change in an instant. And just a quick short story here, a big estate that I'm working on right now, a client, he was an accountant, he was the manager of his, managing partner of his company, had a wife, 3 minor children. He knew he needed an estate plan, so he doesn't fall under this category. He came into my office, we drafted the documents, we reviewed the documents, but he was an accountant and he was busy. So he kept putting off signing his documents. I'm busy this accounting season. And then I'm busy, I'm on vacation. And then I'm busy, the kids are starting school again. And then I'm busy, always putting it off. Finally, we got a call from his wife, who said, I can't even believe I'm calling you to tell you this, but my husband went out for a jog and he had a heart attack and passed away. Now, real life, I promise. There's a big file behind me. You see that file? That's his file. Wife, minor children. I knew what he wanted. It's memorialized in paper, pen to paper, but it was never signed. So not having an estate plan, there are real life consequences to it. So let's move on to the next slide. Second mistake is not planning for while you're alive. So that falls in my toolbox, right? So I said my toolbox, I need planning for while I'm alive. I need planning for when I'm no longer here. So I'll sit down with a client and they'll say, I have my will, I'm good to go. Oh no, you're not good to go. You need to make sure you have your plan in place for while you're alive as well. What happens if you become disabled? What happens if you become incapacitated? So I like to think of my ancillary documents before I even get to the will. If a client says, I'm not sure who I want to name or who I want to leave my assets to, I say, no problem. We got to get your healthcare proxy, your living will, and power of attorney done ASAP. Very, very important. So what are these documents? The healthcare proxy is a document where I appoint somebody to make a healthcare decision for me if I couldn't make it for myself. So if I'm able to make my own healthcare decision, it is 100% my decision to make. If I cannot make it, I appoint somebody to make that healthcare decision for me. The living will goes along with the healthcare proxy. It appoints somebody to make end-of-life decisions for me. Listen, sometimes people don't want that. Sometimes people want to be kept alive on machines forever, to each his own, but it's something to consider. These documents are what I call springing documents. They spring into effect upon a certain moment in time, but they can also spring out of effect. So if I'm in a coma temporarily and I appoint Kyle, you get to make my healthcare decisions. Well, then Kyle, while I'm in a coma, you get to make my healthcare decisions. I now regain my capacity. I'm back in control. Kyle no longer has a say. That's for my healthcare decisions. The power of attorney is everything not healthcare related. So I'm talking finances, I'm talking real estate, I'm talking business transactions. That falls under my power of attorney. The power of attorney appoints somebody to make all non-healthcare related decisions for me. However, it is a very powerful document. Why? Because most often it is not a springing document, which means once I sign it, it is effective. So if I name Alan as my agent under my power of attorney, Alan can technically go into all of my accounts and do whatever the hell he pleases just because he's my agent under the power of attorney. So I will have clients who say, you know what, that document really scares me. I don't want it. Well, now what happens if you become incapacitated and you don't have a healthcare proxy or you don't have a power of attorney? What happens is that somebody needs to go to the Supreme Court to petition the judge to have a guardian appointed on your behalf. So that means if I'm a business owner and I say, I don't want a power of attorney, it's very scary. I don't want to appoint my spouse because they don't know anything about the business. I don't want to appoint my kids because whatever the reason is, because they're young, because they don't understand, because they're not me. Well, now what happens is my loved ones need to now go to the Supreme Court and have a guardian appointed. So that means they have to hire an attorney. That means there's a court proceeding. It's not just I show in court and say, hey, mom or dad or sibling is incapacitated, I need a guardian. No, the judge gets to come in and see, is that person incapacitated? It's a full-blown hearing. So how does it really play out? Two quick examples here. It doesn't always say, you may say, by the way, like, oh, it doesn't matter. My family all gets along. They'll go to the judge and say, my mom or dad or sibling is incapacitated. And we agree that John should be the guardian, and the judge is going to say, okay, that doesn't always happen. So two quick stories here, and they didn't happen to business owners, but let's make a parallel story here because it could happen to a business owner, and I'm sure it happens all the time. I had a young woman, I call her young, she was in her 50s with early onset dementia, did not create her healthcare proxy, living will, or power of attorney. Children needed to handle her finances for her. She had 4 daughters, 3 who got along, 1 who didn't. Everyone agreed she needed a guardian. The 3 who got along hired an attorney, went to the Supreme Court, requested that one of those 3 daughters would be appointed as guardian. Well, the one who didn't get along with everyone was not happy about that. So she actually started a whole long contest over here. At the end of the day, the judge said, I don't think any of you 4 are competent to be the guardian. We're appointing a family friend. If you're a business owner, do you want a family friend running your business? I don't think so. Do you want your family friend writing your checks for you? I don't think so. And the theme is being proactive versus reactive. A more applicable example is I got a call from a friend from college this past summer. So during COVID times, her parents were in the process of selling a house in Queens and purchasing a house in Cleveland. Her parents did not have any ancillary estate planning documents, had no estate planning documents, period, but ancillary to the point here. And her father suffered a major stroke, debilitating, was on a ventilator, and it's COVID time, so visiting in the hospital is limited. Well, the closings, both of them were supposed to happen soon. So we had to pause everything, go to the Supreme Court, have a guardian appointed, which, by the way, delayed everything by 2 months, even though this family, everybody did get along. So that meant we could have lost a buyer, and it meant that a seller could have walked away. If I'm in the middle of a exit strategy for my business, if I'm in the middle of business negotiations, and I don't have anybody who could step in for me, I may lose something very valuable. So it is so important. Just moving on, insurance. I'm sure that we have insurance people on this meeting right now. What's your biggest asset? So one of your biggest assets is your ability to earn your income. What happens if you can't earn your income anymore because something happens to you? So my typical example is a brain surgeon, right, who falls and doesn't have use of his hand anymore. He breaks his hand, he's out, he's done. Who's supplementing his income? Who's making sure that his bills are being paid? What if it's not something as drastic, but who is covering the gap of time where I can't work or I can work? Disability insurance is so important for business owners. Additionally, long-term care insurance. I focus on long-term care insurance because I do practice in elder law, Medicaid planning. Oftentimes people don't think about the cost of long-term care. If I've worked so hard to grow my practice and then I retire, but I need to use all the money that I've earned for my long-term care needs, well, what did I do? I didn't plan properly. Long-term care insurance, it used to be a product that I would pay my premiums for however long I had my insurance. And if I needed long-term care, well, then I paid my premiums, I get the benefit, versus what exists now that's really been phased out. It's now a product like a life insurance, a whole life or universal life insurance product, where I have a long-term care rider, so that if I pay my premiums and I don't need long-term care during my life, so I get hit by the proverbial bus, now my beneficiaries get the insurance benefit as if I've deceased. Or if I need the long-term care during my life, I have access to it. So there are products out there for business owners to make sure that you have the continuity of income so that you're taken care of. You don't want to go the court route. You don't want to have a Supreme Court involved in any of your business decisions, because you can have a judge interfering somewhere. I'll also raise an issue that I have with a current client. He's on wife number 3. He has children from marriage number 1. What happens in that situation if he doesn't have a healthcare proxy or power of attorney? He's in a very lucrative food industry business. What happens, right? So actually, we've updated his documents several times. Every time he has a new wife, we update the documents, because in this situation, if he didn't have a power of attorney, is wife number 3 going to fight with kids over who gets to be in charge of dad's affairs? We don't want to be in that place. So that's the not planning for while you're alive route. Let's move on to the next slide. So we've got our toolbox, we've planned for while we're alive. Obviously now we need to plan for when we're no longer here. So just a brief education. What happens to my assets when I'm no longer here? My assets can pass in one of 3 ways. The first way is what I call by operation of law. So what does that mean? That means if Ken and I have a joint account and something happens to me, Ken, happy birthday, you get now the assets in the joint account. If I have a life insurance policy and it names Sasha as the beneficiary of the life insurance policy, well, Happy birthday to Sasha. She gets the proceeds from my life insurance policy. And can you get my joint account? All because we are joint owners on it, or because you're a named beneficiary, or because you transferred on death, TOD, POD. Anything that has a named beneficiary passes by operation of law. So that's method number one. The second way my assets can pass is if I have a trust. If I have a trust that I've created, whether it's for estate tax planning purposes, gifting purposes, Medicaid planning purposes, maybe I have beneficiaries that are going to fight with each other, whatever the reason. I've created a trust and I've transferred my house to this trust. And the trust says on Keren's death, anything in the trust goes to XYZ charity. Well, then on my death, Ken is getting my joint account by operation of law. Sasha is getting my life insurance policy by operation of law, and XYZ charity is going to get my house under the terms of my trust. So those are the first two ways assets can pass. So under the terms of a trust and by operation of law. The final way my assets can pass is under the terms of a will. Now, the will only applies to assets in my own individual name, no joint owner, no named beneficiary, not in a trust. I don't know about you, but how many business owners that I know who have assets in their own individual name? I just spoke to somebody yesterday who has properties and his business that the properties are own all in his name. Well, if you don't have a will, New York State goes ahead and writes a will for you. So first of all, he doesn't have a will. His properties are all in his name. What happens? New York State or any state that someone resides in has a will that they write for you. It's called intestacy. In New York State, you may think you know what will happen to your assets, when in fact, you really have no idea. So what happens when you don't have a will depends on your family situation. If you're survived by just a spouse, everything goes to just your spouse. If you are survived by a spouse and children, what actually happens is the first $50,000 off the top goes to the spouse. The balance gets divided 50% and 50% between your spouse and your children, regardless of their age, regardless of whether they have special needs, regardless of anything. So that first example that I gave you with that accountant who was a managing partner in his firm, he had 3 minor children. His will wasn't signed. So what do you think that means? That means his spouse and his 3 minor children are now owners, quote unquote, of his business. That is crazy. Who takes the time to build a business but doesn't take the time to think about where their plan goes? Also very important, even if you do have the will, you need to name your executor who is in charge of collecting your assets and distributing it. You need to name someone if you have minor children, or if you have a spouse, if you're in a young marriage or a young family, you want to name a trustee to manage that money. So if you don't have your will in place, you don't get to name these fiduciaries. It's also important to plan for beneficiary situations. So if I want to leave assets to my children, for example, but my son is a famous doctor and is worried about malpractice concerns, I don't want him inheriting my business, because then my business becomes subject to his malpractice concerns. There are so many things that I need to take into account in my will, especially so business succession planning considerations. Specifically, I want to worry about my asset liquidity, right? This is very important to think about. If I have children who are not involved in the business and children who are involved in the business, how do I make things equal amongst all of them? Do I leave the business to one child and make sure I have assets, other assets to go to the other child who's not involved? Or if I have children, so Kyle and I and Alan were just talking before this meeting about having children who are in the business but don't really want to be in the business, right? That's something that needs to come up in this conversation of estate planning as well. Do I want to leave assets of my business to my children? Well, maybe my child doesn't really want to be involved in the business. Maybe they're just doing it to appease me. Do I want someone who doesn't want to run the business to run my business? Not really. That's a disservice to my clients. It's a disservice to my business, and it will likely fold relatively quickly after my death. But at the same vein, do I want to leave things equally to all of my children, even if they're all involved? Probably not either, because there may be differing views. I need to document everything, because if I don't, I wind up with issues. Just a quick story here is I actually have a friend whose father runs a business. It's a phone telecommunications business. 2 kids are involved in the business heavily, run the day-to-day operations. And daughter number 3, so 2 involved, 1 not involved. She is a therapist, has nothing to do with the business, but she manages the family's affairs. So she makes sure that everything runs smoothly. Now, the two kids who are involved in the business want this third sister to have nothing to do with the business after father is deceased. The third sister obviously wants to be involved in the same way that she's involved now. The parents' approach is, I'm not worrying about it right now because I see it creates a rift amongst them and I don't want to address it. So they're not doing anything. And I'm trying to bring them to the table here because what they're really doing is creating a recipe for disaster when they're deceased. There's going to be a huge fight and the business will likely fold if they don't document what should happen. So that's thinking about the later in terms of your will planning. So we can go to the next slide. But also, in terms of planning for the later, is we need to take into account estate taxes. So right now in the year 2021, the estate taxes is kind of like a moving target. So what I'll do for you today is to address the estate tax planning concerns as they exist today, June 3rd, 2021. And I'm not even telling you what's going to be June 4th because based on the American Families Plan that came out yesterday, things may change. I'm not sure. So as they exist today, there are two estate tax concerns we have as New York State residents. We have the federal estate tax and we have the New York, it's a federal estate and gift tax and the New York State estate tax. So federally, I have $11.7 million per person per person that I can use. It's an estate and gift tax. So that means I can give it away during my lifetime. Whatever I don't give away during my lifetime, I now have at death to use. It is what's called portable between spouses. So for example, if I only have $2 million of assets, but my husband has $15 million of assets and I die first, he actually gets to claim my unused estate tax exemption amounts. He gets to keep the 9.7 that I didn't use and use it for himself. So it's really between the two of us, $23.4 million. It's quite high. It's historically high. Additionally, I can have as much as I want and leave it all to my spouse, and there will be no estate tax. The government sits back and waits till the death of the second spouse till they grab the money. Currently, the maximum federal estate tax rate is at 40%. Why is this relevant? Because Biden has proposed reducing this number to $3.5 million. There is a proposal, there is a proposal to separate the estate and gift tax to make the gift tax only up to $1 million, and any amount over $1 million is subject to gift tax. There are so many moving targets at this point, but as it exists today, and by the way, if any of you have high net worth clients, it's worth having a conversation with them as to planning. But this is something that you need to take into account for all your business owners, and even more importantly, as a New York State resident. Why? The New York State estate tax exemption amount is significantly lower at $5.93 million, although it is also historically high for New York State. But there is no portability, meaning it's my own $5.93 million that I can give at my death, but I either use it or lose it. I don't get to share it with my spouse. I can leave it all to my spouse, estate tax free, but then New York State's going to come in after the surviving spouse's death and put their clause in it then. But more importantly for New York State, there's something called a cliff. If I have over 5% of $5.93 million, so let's call it $6.2 million, I am going to be taxed all the way from $1 of my assets after I die. So I don't get any advantage of the $5.93 million. It's as if it never existed. I've jumped off the cliff and I have no benefit of an estate tax exemption amount. So if my business or I am close to that number with my business, I need to make sure I do the proper plan. And why is this so relevant? Because I'm speaking from my experience, most business owners have an unrealistic value of their business. It is so important throughout the whole conversation. I see Alan shaking his head, but it is so important to have a team of people, as Sasha alluded to before, working with other team members, so to speak. You need to have your accountants. You should have a qualified business appraiser on your team to help you value your business. It's important for exit strategy planning. It's important for thinking about asset liquidity. It's important for thinking how you're dividing your assets amongst your beneficiaries, but you have to take into account the tax consequences. There's very little you can do with a business that does not have a tax consequence, whether it's income tax related, estate tax related, capital gains tax, gift tax, any tax. It needs to be planned for proactively versus reactively. And now we can go to the next and final slide. Great, you've done all of your estate plan. Oh no, you forgot to update it. So quick story here. At the height of COVID last summer, I got a call from a friend. His father was doing COVID cleaning, I'll call it, right? Everybody was like cleaning out their closets, garages, you couldn't go anywhere. He was in his 70s. He was cleaning his closet, his garage rather, and he fell. He had a very bad fall and unfortunately was in a coma. It wasn't looking good. Visiting at the hospital was very limited. They were able to get in one at a time a day. So one person a day, because it was so drastic. The situation was so drastic. He ended up passing away. But he wanted to update his will. The family wanted him to update his will, but he didn't have capacity. We weren't able to do it. They weren't able to find his original will. They did find a copy of his will. And the copy of his will referred to a formula that estate planners used 20 years ago. Why? Because the estate tax exemption amount federally 20 years ago was $675,000 versus what it is today, $11.7 million. If they had found his original will, and that's a topic for another conversation, if they had found his original will and we needed to probate his will, there would have been extreme tax consequences. He had a very valuable business, a very valuable estate. It would have been crazy how much estate tax would have been due because of his will having not been updated. Even more so, he had a son who predeceased him. His son was married. It was a long-term marriage. So he was in his 70s. His son got married young. I think they were married like 25 years, a significant amount of time. The family feels that the daughter-in-law is the daughter at this point and wants her included as if she is a child. The family all knew that, but he never memorialized that in any paperwork. So because we have to go the intestacy route, because we couldn't find the original will, that daughter, that slice, gets treated as if she's not there and she gets skipped over. These are all important concepts that come up. It's important for his business. It's important for his family to feel confident. So in addition, you want to make sure your beneficiaries. So I talked about having things passed by operation of law under the terms of a trust, under the terms of your will. You want to make sure everything is consistent across the board. You definitely want to update your documents. I say at a minimum every 3 years, but anytime one of the 5 Ds happens, death, disability, divorce, new descendants or distance, anytime that happens to either you, your beneficiaries, your fiduciaries, you want to update your documents. Just one more, I guess, example that I'll throw in here that's an estate planning mistake that I see with business owners is my very first estate that I ever did when I was a lawyer. A son in his mid-20s came to me. His father was diagnosed with pancreatic cancer. He knew he was going to die. His wife left them, so she was completely out of the picture. So we have a father who was diagnosed with pancreatic cancer, a wife who was completely out of the picture, nothing to do with the family. They got divorced. She never visited the kids. She's out of the picture, like I said, and 2 kids. So the son who's in his mid-20s and a daughter who's a minor in 10th grade in high school. The father who was diagnosed with pancreatic cancer was in the garment industry and had a booming business in the garment industry. His 26-year-old son helped run the business. He was his right-hand man. He knew he was going to die. He said, I'm not going to spend the money on a will. I am going to do it myself and go online and take care of it. Well, let me tell you, what did he do? Instead of leaving his business to his son, which was his intention based on the notes that he kept with his documents, he left everything 50-50 between his son and his daughter, who's a minor in high school. So you have the 26-year-old son who's now left picking up the pieces of his father's business. His mother is not in the picture. His sister is in 10th grade in high school. He also, by the way, didn't put any guardianship provisions in for his sister, for his daughter. So now the 26-year-old not only has to pick up the pieces of the business and of the deceased father, but now also take care of the minor sister. It is so important. I can't stress it enough, proactive versus reactive. And I'll leave you with my favorite quote is failing to plan is planning to fail, whether that comes to yourself or your clients or your businesses. It's so important. That's all I got, Kyle and Alan. Feel free to ask me any questions or so Kyle and Alan and I were discussing some examples of real life clients we've had and crazy stories. So does anybody have a story, I guess, that they'd want to delve into? Don't all shout at once.
Oh, I
Yeah,
was,
no
this
takers.
is Sasha.
Oh,
I really enjoyed your presentation. Thanks so much.
Thanks,
And I
Sasha.
love what you say about being proactive versus reactive, because I stress that with clients all the time. One thing that I think people neglect is the healthcare proxy. I've mostly been in healthcare a long time, so I knew about it, from years back, and it's become more popular. But how do you convince, and when do you usually convince people to sign something like that, especially when they're in, relatively good health?
So that's the best time to have these conversations, when they're in good health. And just as a point of reference, I like to stand on my soapbox, so to speak, so much about the healthcare proxy and power of attorney that I do free college student packages for healthcare proxies and powers of attorney for any college students, because it is so important that anyone over the age of 18 have these documents in place. How do I have these conversations? None of this, and forgive my words, none of this is sexy. None of this is enticing. Nobody wants to talk about
right.
any of it. Nobody wants to think about what's going to happen if they're sick or disabled or incapacitated. But the proof is in the stories. So that friend who called me and told me that her father just had a massive stroke, can you imagine how she must have felt? She was in tears taking care of this for her parents. So I do, gently have these conversations. I also, it depends on the client, right? It depends on their age, how you address the conversation. But the most important for me is that my client feels comfortable. So there are a few different kinds of healthcare proxies you can have. There's a healthcare proxy that says, I do want XYZ, I don't want XYZ, and that makes them uncomfortable and makes them think about things they don't want to, versus a blanket healthcare proxy, which is my preference, and I'll go into it another time, but it essentially says, I appoint Sasha as my agent under my healthcare proxy, my agent knows my wishes. And that allows me to have an offline conversation with you as to what my wishes are. And it allows you to understand what my wishes are without putting it in the paper. So in the events, like something that I saw in the beginning of COVID was with ventilators. So people would have a healthcare proxy that said, I don't want to be put on a ventilator. But in the beginning stages of COVID, ventilators were being used as treatment. If I had a healthcare proxy that said, I don't want to be put on a ventilator, well, then my agent kind of had her hands tied. But if I said my agent knows my wishes and my agent knew that I really just want to be kept alive until, this passes, well, then I would have been put on a ventilator. So that does kind of ease the conversation. So I hope that addressed your question, Sasha.
Yes, thanks.
Any other questions?
Chomping at the
While we're
bit.
on, I can't see if anyone's got their hand raised. While we're on the topic of healthcare proxy, Keren, can you just address how various states, whether they recognize or don't recognize proxies from other states, right? So if I live in New York, right, I get my healthcare proxy here in New York, but I'm on vacation in another state and something happens to me, generally speaking.
So that's a great question, Alan, because like I said, I do this for college students. And so oftentimes you'll have a college student who lives in New York, their parents live in New York, but then they go to school in Michigan, right? Technically, and I say technically, as long as the document is valid where it's executed. So if I validly executed it in New York, it should be acceptable in the other states or other countries, by the way, if you're abroad. That being said, you encounter hiccups everywhere, always. So if you're going to be abroad, I would oftentimes have that school just look at it, make sure that it would be approved. So oftentimes people don't even know this is a service. You can now give, I know that I had a client whose kid was going to Israel, and that program would review your documents to make sure it would be a valid document there. So it's definitely something, if you're going to be there for a while, I would have them check. If you're there temporarily for a vacation or something, I wouldn't be all that concerned. Again, as long as it's validly executed where you live. The same is true, by the way, of your estate planning documents for when you're no longer here. So that's that.
I think Steve Alberti's got a question.
Yes, hi, Keren. Yeah, if I could go back for a second on the healthcare proxy. I find interesting in that you're saying you prefer a general proxy rather than a very detailed one. So, for example, the hospitals, Northwell, Suffolk, are not getting out these 3-4 page healthcare proxies with very specific questions about being on a ventilator, having a feeding tube, how long you have the feeding tube, how long you're in the ventilator.
So yes.
What, all these different
Well,
things that,
when
yeah.
you walk into Northwell, for example, for a procedure, that's when they say, do you have a healthcare proxy?
Right.
If you say yes, your blanket one, here you go. Why do they have you do that detailed one? Because they're CYAing themselves.
coming to rash, yeah.
So
Right, yeah.
that's exactly what's going on there. So all the more reason why you want to be proactive and say, hey, Northwell, I've got my own, here it is. Because again, you don't want to be in a situation where, and not to say that I'm knocking any doctors, I'm not, but you don't want to be in a situation where a doctor says, hey, I see Steve said, no ventilator. What does he mean by that? Maybe I'm not going to do X, Y, Z because he could end up on the ventilator. And not to say that that's the situation, but you really never know. So I would always, again, that proactiveness, have that healthcare proxy to give to them. Also, just a point on that is that healthcare proxy, I'll oftentimes have clients say, oh, I have a healthcare proxy, but that's really from when they went in for that one procedure, that one time at Northwell. It's not a blanket one. You can't use it, when you go to St. John's. It's just for that one place.
One place, yeah. And again, your feeling is keep it general and let the appointed agent make those decisions.
Yes.
Rather than be too specific in spelling it out.
Absolutely.
And I think John had his hand up too. He had a question.
Hi, Karen. That was a really great presentation. I've heard many of these presentations, and I have to say, you always learn something new. You always think as an attorney, you just think, oh, it's the same old thing, but it's not. There are wrinkles, it changes. It's so important to keep good communications with your estate planning professionals, and people just don't do it. My clients dust off files and they ask me to look at it, and I don't know how to look at these things. It changes too much. One of the unfortunate issues that come up is financial institutions tend to be very slow to accept powers of attorney.
I'm so glad you just mentioned that, because the power of attorney law is changing on June 13th. There is going to be a new power of attorney form. Old ones will be grandfathered in, so don't get nervous. But a feature of the new power of attorney is that banks have a specific amount of days for which they can either accept or reject powers of attorney. So if they don't accept or reject it during that time, it is actionable. You can sue them, but you're not gonna encroach on that time, because banks were involved. The banking section of the New York State Bar Association was involved in this law, involved with the new power of attorney. So that should, that should resolve some of the issues, because that has been a big issue. And especially on the elder law side of things, we've encountered issues, because if we're doing things for elder law, we need to move fast. We can't wait the months that it's going to take for you to turn things around. We need to know, are you accepting it? Are you not? Why not? Let's move forward. So now they have to answer within that time frame. And if they don't, they're out. And I don't have the time frame in front of me right now. I believe it's 10 to 14 business days. So it's not like months. We're talking like right away.
When I'm doing any private equity deals or venture capital deals involving foreign money coming into the States, working with the banks is like peeling an onion.
Oh yeah. And yes. And by the way, different banks and different branches of different banks and different relationships from different branches, or even the same branches, you may get a different answer. So I'll always tell my clients, try this branch that you usually go to. If that doesn't work, go down the block to the next one. You'll find one, just keep going.
It's an amazing, you learned that as an attorney, that not everything that helps a client you learned in law school. So
yeah. They don't teach you what you need to know in law school, that's for sure.
A question, is there any way to double down, get something on file? Well, let me lead by an example. For example, when we needed a bank to do something, because the bank's back office found a letter of instruction from one of the partners of the LLC, who we knew would be out of the country, and they wanted all the partners to come in and sign in person. They wanted to see them, because I work with a lot of international clients. The fact that a notarized letter acknowledged by one of the notaries at the bank was on file, it seemed to speed up the back office. It's like almost, if you hear someone else saying the same thing, the back office exhales and approves whatever it is. So I'm wondering if there's, although the power of attorney should speak for itself, is there any experience you have with what you can do to add something to the file to get the back office of the bank to
Like you said, a letter of instruction sometimes works. Oftentimes, though, if I'm filing a power of attorney, it's because that person can't sign a letter of instruction. So no, just I work on the client relationship. It's so key, and it's becoming less common, especially this day and age. That client relationship is so important to have with your bank. Go in, show your face, deposit a check, and walk out. But just so they know who you are when you walk in, it's so important.
Yeah, well, we're definitely on the cusp of how things used to be and how things are going to be. But you're right. You know, that FaceTime with your banker just doesn't exist anymore. And I think most of us have had that experience where it's helped us. But I wonder if my niece and nephew are going to feel the same way.
No, they're not. They're not going to feel the same way. They're going to say, "What is a bank?" Yeah. But to that point also, if they know who you are, so there's got to be some way that there's a relationship created with a bank, whether it's via email, whether it's via, I don't know, some cloud arrangement. Be active. Don't just be passive in that relationship. And especially as an attorney for our clients, if I create a relationship with, I don't know, Chase Bank, and I have this contact that I always call, and if my client gets into a situation with a different branch, I'll just call my connection and say, "Hey, this is what's going on there. Can you help, or can you speak to someone who can help at that branch?" So from a professional perspective, it's important for us to also retain those relationships.
And the last thing I'll say, it's clear to me that you really enjoy what you do.
Thanks.
That makes it fun to listen to you.
I won't tell you if it's true or not, but thank you.
I can share if you guys don't mind.
Okay, and then Mark had his hand up as well.
Thank you, Alan. Hi, Karen. It was a really great presentation. One of the things I particularly liked about it was you're bringing in a lot of stories, a lot of anecdotes from clients, many of whom you have a personal relationship with, but I'm sure not all of them. But there were certain situations where you encountered resistance to the ideas that you were trying to legally give them legal advice about the value of these different aspects of what you just shared with us. I'm just wondering, like, what's been your experience in helping people who at least initially have that wall against hearing anything? I mean, there are different levels of it. Some people don't even want to think about their demise, let alone being, you know, in a coma or paralyzed. But especially in the business context, to try to get through to that person about the value of putting these I don't know what you call them, these legal documents in effect. So I'm just wondering what that's been like for you, and, you know, how often are you successful? How often do you just say, well, I can't get through to them, and that's about it?
I'm always successful, Mark.
Pretty good. You bat 1,000. Not too many people.
I'm kidding. I think, listen, it's hard, but I think that the constant is just to be patient and understanding. So just to be patient for your clients, and give them the space that they need to process what's going on. So whether that's due to a business divorce, which by the way is traumatic in the same way that a relationship divorce is, or whether that's to contemplate disability or death, oftentimes when a client comes to me, it's because something happened that made them realize that they need to come to me. So it's hearing their story, and I would say it's I have a different approach than most attorneys. Estate planning is not like Eminae. I'm not coming in and doing, you know, this is the deal, this is the offer, are you taking it or you're not taking it? It's not like that when it comes to me. I would say I'm more of like a therapist than an attorney when it comes to my clients. And so it's just that patience and understanding that I don't have for my family, but I certainly have for my clients. So it's channeled all here. I don't leave any for the personal life, but it's that patience and understanding. And I'm sure, Mark, that you have to deal with that as well in terms of coaching. You know, you have to see your client's perspective almost and step into their shoes.
Absolutely, Karen. And you're saying it so well. Patience is important. Empathy is important. Allowing them time to digest what you're saying, because a lot of what I think the rationale for everything you're talking about is very rational. but a lot of stuff that you're dealing with is emotional. It's irrational. It's fear of the unknown. It's fear of being unable to function or dying. So I think what you said is right on target. And I have that feeling about you that, you know, you can listen and you can give your clients that space respectfully, but also letting them know how important it is for them to not ignore it. And ultimately, it's their choice. You can't force it on somebody.
Yep. Yep. Absolutely.
Yeah. Thank you.
Which could be a perfect segue into just an open discussion in general. We've all probably had challenges with our clients, maybe not necessarily specific to estate planning, but getting them to make a decision on a recommendation that we've made, and they're hesitant, right? And I think in the case of, you know, estate planning, like both Keren and Mark just said, there's an emotional aspect to it, because I know of the financial planning clients that come to me, it's the number 1 and the number 5 on your list, Keren. That's the most common. Either they don't have the documents, or they have the documents and they're out of date. And on the number 1, when they don't have the documents, just like that account manager of the accounting firm that you mentioned, you know, he said he was too busy, but there was probably really some other underlying reason why he was really hesitant. And sometimes it's superstition. They're afraid, well, if I sign the documents, I'm going to die the next day. I'm going to get hit by the bus.
By the way, Alan, when a client says that to me, they're like, I'm worried I'm going to get hit by a car crossing the street after. I always say, when you sign your documents, it's a sign of good luck for what's to come. You'll have a long life and health and happiness because you took care of this. So it's like a Murphy's Law type thing. So that's what I tell them. So I don't know if it's true or not, but I pretend it is.
No, that's great. So I don't know if anyone has a story they want to share just with a client that maybe was hesitant on following through on a recommendation you made, and what you kind of did to get them to the finish line.
Yeah, I can jump in here. I got a couple stories I could tell. For the sake of time, I'll keep it to 2, maybe 3. Last year was a rough year for a lot of people, and I had 3 prospective opportunities that came to me because where the owner passed away due to COVID. And in all 3 circumstances, there was no estate plan in place. There was 0 plan, no appraisal of the business, no succession plan, nothing at all. Luckily, we batted. Well, two of them I didn't take on as a client. I tried for one of them, but I'll get into that one in a second. We weren't able to help them. Just had too much legal challenges. In that case, it was a insurance agency. And the wife, she was a licensed agent. The husband worked for the school system, worked for the Department of Education, and she had passed away untimely due to COVID, and just had too much legal problems just to even proceed with a sale, because at that time the courts was closed, and there's just issue having to transfer any authority for him to make any decisions because he was not named on the business. So crazy disaster. We had a couple folks, actually Joe Melizio and the team is actually one of the attorneys that actually was helping us work through this particular situation. But it turns out that there's a lot more to the story to be told. The wife had some alternative, what's the best way to say this? She had some other plans with her estate that did not include the husband, and that created some complications for him when he tried to gain access to the books. That the accountant, which was kind of mind-blowing to me, the accountant refused to share the books with the husband, and the attorney the same as well, almost want to X him out of the entire thing. So that was one, our hands was tied, we couldn't really help. We did have a success, well, I shouldn't call it a success story. We did help out this other family where it was an air testing and balancing company, similar situation, no plan in place. The father passed away. The son was in the business, kept the business running. It turned to be an unfortunate circumstance because if they did have a plan in place, you mentioned the 5 Ds, debt, disability, and so on, they could have had some sort of plan in the event that the owner passed away. Who takes control of the business? How much the business sells for? Who do we sell to? Do we do a option to sell to employees? Or they didn't have anything like that in place. The family was very cooperative in this particular circumstance. However, you know, when you're dealing with a death in the family, that's your main focus, and everything else is on the sideline. So it definitely hampered negotiations, and we could have definitely get, you know, twice times more, but at least we was able to, you know, get something for the family in that particular case. But you know, I tell most of the clients that I service, I at this point I have a little bit of a hindsight. I have a little bit of a gut feeling that something is going on behind the scenes. I had a client I work with that I mentioned, Alan and Karen, you guys are talking about, you know, collecting information. We have the same problem too. You know, when we have to do evaluation or an assessment or a SWOT analysis for a company, we need to collect documentation, and it's tough, as you guys know, collecting information from clients. And I had this one client that was taking so long to get stuff back to me. It took 2.5 years to get me tax returns. Right, every year he'll call me, say, "Kyle, I'm ready to move forward." I say, "Well, hey, Jim, this is what I need. So you know the drill." He say, "I'll get it to you." Never get it to me. He calls me up last minute, very, very frantic. "Hey, Kyle, I need your help. I need to get out." And I sense, you know, something was up. Just getting straight to the point, I was able to help him. We entered into a contract to sell the business, and right before we were to close, then he dropped the bomb on me. He told me, "Hey, you know, I have cancer. I don't know how long I'm gonna make it through this, and I don't think I go through the deal because you know, part of my commitment to the buyer is to stay on board and help him, and have no one else in my family to help me out, and so on." So it was a very, very tough situation. And you know, when he came to me 2.5 years ago, we could have helped him and get someone like Keren on board to kind of help him put a plan in place, so we could have gotten him much more for his business. It was a complicated sale. We managed to get it done. He was losing his lease as well. He didn't own the property, but we got it done. But it's a tough situation. Like Karen, you say, you don't want to have these stories, but you kind of have to have these stories. Personally, you know, my brother had passed away, and he passed away the day before my mom signed his policies. So when he passed away, we didn't have any insurance to bury him or take care of him, his funeral expenses and so on. So I mean, it is tough. Like, some people just delay, and you know, I hate to say the older generation, but my parents know, like, you just delay. Like, you know, you need to get this done. You think if you sign this document, it's you almost put it into the ether that something is going to happen, and you put it off. But fabulous presentation, Karen.
Thanks, Kyle. It is definitely, by the way, something I think maybe the older you get, the less you want to do these documents. I wouldn't say it's the older generation. It's every older generation.
Right.
There's something holding them back. And I see that a lot actually with an older single individual, even more so, which you'd think should be the opposite because they've gone through it, losing a spouse. But it's typically when I have an older widow, she does not want to do it. She gets nervous. So it's interesting. We could probably do some sort of statistics on it, but proactive, it's all about the proactive.
Well, again, sometimes it's just about facing your own mortality.
Well, yes, that too, Alan.
Not seeing any other hands raised, no other comments or questions before we wrap it up. Oh,
whatever you want to do. I mean, I have war stories. Unless you want to wrap up, it doesn't matter.
Good question before we hear Ken's war stories. Is there a tri-state area or just a location where you service clients and where you don't? How far out do you go with your firm and your estate planning?
Sure. I'm only licensed in New York, but I do Nassau, Suffolk, Queens. I'm going to forget. I go all the way up to Rockland, Westchester area, and everything closer. So Nassau, Suffolk, Queens, Kings, Bronx, Westchester, Rockland. Did I forget?
Boroughs. You did the boroughs as well.
Yes. Alan, did I leave anything out?
no, I think geographically you're fine.
Okay.
No, thank you.
Thank you.
Go, Ken, tell us your war stories.
Sure. Well, Karen, by the way, great presentation, and congratulations on making partner.
Thank
We
you.
announced in another group that I belong to with him. So great.
Thank you.
Well, a bunch of years ago, I had a good client, third generation, two brothers running it. One was 40, the other was 48. One of the brother-in-laws was a partner in a planning group, big planning group, did all the estate stuff for them. The 40-year-old all of a sudden had cancer. It went very fast. And in a matter of months, he was gone. Now, the way everything was written, in the shareholders agreements and it was clear, but the formulas become, his part of the business, it was all underfunded to buy it all out. So the brother took part, and another consultant, outside family member, to own a portion of this business and turn this business into hell. That was actually during the period where I exited. And needless to say, they eventually got her out, but the brother did it using his kids and putting them in. Now, the person who died had a 10-year-old son who got screwed out of his share of this business, which is still going on today. And, I would say when he turned 18, I got a letter from a lawyer that he retained to go and fight for his share of the business, because of the inside knowledge that I had. And it was a whole mess. So, another quick story. I had picked up a client years ago. She was no longer a client, where the father ran the business with the mother. He had a son and he had a daughter. The son always worked close with his father. The daughter, did whatever she did. Eventually, she took over the books, moved out to California, did the books from California. She was embezzling a whole bunch of money. We had to wrestle the books from her, get copies of all the files, and then we had to go after her, with the mother always making excuses for the daughter, because the mother was still alive. And it became a big mess. So, it's, again, nothing, no planning. And then another Joe Malizio story is I said a lot of bookkeeping reconstruction of late. I picked up one a week ago, which was a Joe Malizio client the woman's husband passed away suddenly. And she was left to run the business with very little knowledge, no training. It's a small business. She's got no help, and she's getting eaten alive right now. No planning, succession planning of any kind. So I try to make everything quick. So I could give more details, but I'm watching the time.
Right. Thanks for sharing, Ken. Any other last comments? I don't think so. All right. Well, and thank you very much, Keren. It was a great presentation. We enjoyed it.
Thank you.
I also enjoyed co-hosting. So thank you again, Kyle. I'm going to actually turn it back over to you in case you have any closing comments or housekeeping things. I don't know if we have any upcoming dates that we all need to be aware of in terms of meetings or M&A events.
Thank you, Alan. Fabulous job. And Keren, as always, fabulous. It is not an easy topic, but I think the way how you present it, it just comes across well. And I'm sure you bat 1,000. I know you're very humble, but anyone that's working with you, they get in represented well and provide a top-notch service. Yeah,
of course, that's how she made partner. She bats 1,000.
Yes, definitely. So thank you guys again for attending. Look like one thing about our roundtables, we always finish on schedule. It's 1:28. About we want to respect everyone's time, and we appreciate